Hey, I'm like, we're live now.
Okay, Yuri is calling. Hold on. Hello? Go ahead. Is it live now? Okay. Okay, guys. Go ahead.
Good afternoon, everybody. Welcome
Talk
back.
a little louder, Kishore.
You still can't hear me?
No, but you talk louder.
Okay. Good afternoon, everybody. Welcome back. I apologize for the inconvenience. We have some technical difficulties, so we had to pause the presentation, and now we'll be continuing with the presentation. Like we started earlier, uh, we have a full forum here today. We'll be discussing about our um, immigration changes with the October bulletin recently, and we have our President Vijay Shekhar Anya garu and our um, Sharda Kodam garu from Kodam Law Firm. She's our speaker today. We have our Banu Lanka, who is our zonal vice president, and Rajendra Katragar garu, Dallas chapter coordinator. So we'll be continuing with the presentation now by talking about a brief about the North America Telugu Society. President Garu will give a brief about that, and then we will continue to Sharada Garu for to discuss about this
Yeah.
today's main topic about the immigration. President Garu, please go ahead, Andy.
Hello, Andy. Andak namaskaram. Sorry for the inconvenience caused, and we really apologize for that. I would like to make it brief. We have our 24/7 helpline in NATS. If you, in case of emergencies, please dial 1-888 for Telugu or helpline at natsworld.org. Without any more delay, Shraddha ma'am, please take over and let's continue the presentation. Thank you.
Sure. Um, Thank you, everyone, for patiently waiting. Really appreciate it. I'll start from the beginning again in case someone missed something. So today we are talking about the EB2 to EB3 moments. And before I proceed, fair warning that this is only for educational information purposes. You should be speaking to your attorneys to make sure the information that we are providing works in your case, and make adjustments as needed. Please don't follow this. Please don't consider this anything more than education and information only. Now that said, the first question that everyone is wondering is, hey, why is there a movement in the dates? Why did suddenly India get so lucky, right? And one of the reasons being, October 1st is the beginning of the USCIS fiscal year. That is, we have the quota available as of October 1st. So that is the reason why you see H1 starts on October 1st. So likewise, the immigrant visa, the GC starts getting issued from October 1st. Now, the way it works is, there are 140,000 visas, green cards issued for an employment-based category. 7% of the 140K is issued on a per country basis. Now, in that 7%, 28.6% is assigned to EB1, 28.6 assigned to EB2, and 28.6 assigned to EB3. What is not used at an EB1 level pours over into EB2. What is not used in EB2 gets poured over into EB3. Now, we also have a regulation that says that, hey, if any family-based visa, they have their own separate quota, right? If it doesn't get used, then that gets poured over into the employment-based quota, and the country that is most oversubscribed, they get a preference. Now, what happened is, because family-based petition is usually determined at the consulate, and consulates being closed due to COVID-19, there was considerable excess that was sitting in the family-based side that got poured over into employment-based petition, and India being oversubscribed, we got a higher chunk. So that is the reason for the dates. It's nothing beyond mathematics and combinations. That is all that there is here. There's no ulterior motive. Now that said, how do we know how many visas are going to be issued and what is the process involved? Now, the Department of State through Charlie Oppenheim, he determines how many visas are available to be issued, and he does that by calculating, talking to various consulates and USCIS to see how much is available. Now he comes up with two different charts: a chart A, which is called the final action date, and a chart B, which is called the date of filing. Final action dates are dates that mean that USCIS can start issuing the green cards. So people who have filed 485 based on the dates, if they are current, then USCIS can start actually giving them a green card. The date of filing that we are seeing is used for people to say, okay, start collecting the documentation, start preparing, and file your 485. That is the difference between the date of filing and the final action date. Now, USCIS, based on even though Charlie says, hey, final action is for giving the green card and date of filing is to file the 485, USCIS, for whatever purposes, determines what chart that should be used. That is the reason why the date the movement was happening, the visa bulletin was issued. You saw that USCIS was going back and forth. They first said final action date, then they said date of filing. It was complete mayhem and chaos that day, but it was because USCIS looks into its own pool and see what they can do. Now USCIS came back and for October bulletin, ironically, they came and said, hey, date of filing is what you should be using to file your 485. And as we know, the date of filing moved considerably for India compared to others. Now, let's talk about how, now that we know the dates have moved, now let's talk about how does this whole employment-based green card process works. I know for a lot of you, this would be it's common information, but I will go through it just so that there are nuances that you should be picking up and that helps answering questions later. Maybe I just answer your questions right now. Now, the first step in an employment-based green card petition is the PERM. PERM is filed with Department of Labor. So in essence, an employer A, goes and tells Department of Labor, goes to Department of Labor and says, hey, Department of Labor, I have this position of a software developer. The person is going to be working in Dallas, Texas, and I need them to do jobs ABC, and I need them to have a master's with 2 years experience ideally. How much should I pay them? So Department of Labor, based on this requirement, comes and tells employer A, hey, for this software engineer position, you should be paying. The employer goes and does recruitment and has to prove that there is no US worker who could do that work except for the foreign national. Once they determine that, they go back and tell Department of Labor, boss, we searched and we tried to hire US workers, but we couldn't find anyone who can do better than this great foreign national that we already found. And here, can we please file our PERM? Once you file the PERM, you get the priority date. Your priority date is nothing but your ticket to go stand in the queue, right? Think of it as a ticket to get on a train you just bought a ticket to get on your train that will get you your green card. That would be my analogy. Now you get the PERM approved, and within 180 days from the date the PERM was approved, you're required to file a petition I-140. It is done by an employer. Basically, we are going and telling USCIS that, hey, we looked for the person. Department of Labor said I could hire him. I have hired him. Now can we go and put them on, can we go book a compartment on the green card train so that they can go sit inside it? So the employer gets to decide what is the basis of classification. Do they want to do it as an EB2 or an EB3? It is completely dependent on the employer. The employee at this point has no say in it, technically speaking. Now, when you're buying a ticket to the train, you can buy two tickets. You can buy a ticket to your AC and you can buy a ticket to your first class. What that essentially means is, based on the same perm, you can have a ticket, you can have an EB2 and you can also have an EB3 for the same, based on the same perm. What is important with an I-140 is the employer's ability to pay. You would hear this term, ability to pay, or ATP as we commonly call it. What it means is, from the time that your perm was approved, the employer would have to show through their tax returns or audited statement that they have the ability to pay until such time the prevailing wage, the PWD, until such time that the employee gets the green card. Now, this is important. Let me give you an example. If a prevailing wage came out to say 100K and you are getting paid 150,000, then the employer has already shown that he's been able to pay that, because 100K is less than 150, so he already has the ability, he already has proven the ability to pay. Now let's take the example wherein your PWD is 150 and your 150 and you're currently getting 100K, then your employer has to show that year over year, until such time you get your green card, that they have that additional 50K that they can carry on their shoulders. Now you'll have to say, hey, 50K is not a big deal for my employer, but you'll have to factor in how many such employees are there, right? So that is the reason why the ability to pay is critical. A common question that everyone asks us is, can I port my priority date? I work for employer A, I like to move to employer B, I got a full-time position, I got a better opportunity. Can I carry my priority date? Because your priority date is important for you, because based on the priority date is when you're going and standing in line. You don't want to go back in line in the queue and stand for no reason. Now, if your 140 is approved and it has been approved for more than 180 days, you can definitely carry forth your priority date as long as your new position in the new company is similar to the old one. What that means is the job duties would have to be similar, and you can port the priority date over. When you port the priority date over, it is not just going and filing another 140. The new company has to go back in, file a perm, and show that they couldn't find a suitable US worker either. And they've tested the labor market, and then you're filing the 140, and then you port the priority date. This is important, guys. This is very, very important, especially when it comes to the EB2 to an EB3 downgrade and so forth. Now you file your 140, you're happily standing, you're waiting in your compartment, hoping the train moves. Now the train moved and you have come to a point, you came to the station filing the date of filing, and now you need to file your 485. To file your 485, one of the things that you need to do, you have to remember that the company that filed your perm and has filed a perm and has an I-140 approved, only they can file your 485, help you file your 485. If you are working with a company that has still not finished your perm, has still not gotten your I-140 approved, they cannot file your 485. This is very important. And you may ask me why, because technically a 485 is an adjustment of status, or the AOS. So, you would come to me and say, hey, Sharda, how does it make sense? I, as an employee, and I'm trying to adjust my status from a H1 to a green card or an L1 to a green card. Why is it that I need to work with the same employer? The reason is very simple. You need to show that there is work that is still available. The job offer, even though it's in future, is still currently available, and the means of showing it is through a form called I-485J, commonly known as Supplement J. So the petitioner who filed your perm and has your 140 is required to support the 485J. Now, we get another common question that we get is, hey, why can't my new employer file it? Even though I don't have an 140, but my date is current, why can my new employer not sign my 485J? The reason number one, your new employer cannot file your 485J unless, as I said before, the perm and I-140 is not approved under them. You can port it over to the new employer only after 180 days of filing the 485, and that is used through AC. That is done through AC 21 rules. So if you don't have the 140 approved through your employer right now, please be careful. You cannot file your 485J. I'm sorry, I'm reiterating it over and over again because that is a common misconception that is out there. Now let's talk about EB2 to EB3 downgrade. So a couple of things. So the question is, like I said, can you do a downgrade? Yeah, we can do a downgrade. And the reason is because remember when we spoke about the perm, we said based on one perm, you can have multiple tickets on the train. You can have a AC ticket and a second class ticket like that. You can have an EB2 and an EB3 based on the same perm. So it's absolutely allowed as long as, and 140 was filed based on a perm, you can file a subsequent EB3 140 and that is allowed. Now, the question that we have to think about is it prudent to file downgrade and file? And this is where I would say use caution, think about it. The urge to downgrade is pretty high, and I'll agree it is very tempting, but please think about it. Now, let's go back to the date of filing. Now, we have already been told by Ayla, and Ayla, talking to Charlie Oppenheim, believes that the EB2 date is going to move significantly next month in the November bulletin. In fact, they've said it is going to move by months. That is the information that was given to all immigration lawyers 2 days ago. So you might want to think if you are very close to an EB2 date for India, you may want to wait and just file a 485 when the date moves. So something to think about, right? It's easy to downgrade, guys, but it's simpler to just file a 485, right? So you might want to think if you should really do that. Now, you have to remember when you're filing a downgrade, what it means is you're coming from EB2 to EB3 and you're going to concurrently file your 485. When you're doing this, your 140 cannot be filed as premium. To file your 140 in premium, you need to have the original perm, which you obviously won't have because remember, you've used your original perm with EB2, so you don't have one with EB3, so you have to pretty much wait. That is something to consider. The other thing to consider, remember, is when you file a new 140, the new 140 is going to be treated by USCIS as a new petition. That is, just because they approved your EB2 then doesn't mean that they will approve your EB3 now. They're going to treat it as a new petition. When we are thinking of a new petition, there are a lot of things that we have to consider while downgrading. We need to see how the perm was filed, what was the recruitment results, and 3, mainly, has the employer maintained an ability to pay? This is very, very important. Now, remember, you'll have to show the employer's ability to pay from the time your perm got approved. It is not from the day that you're filing the 140, it's from the time that your perm was approved. So if you are looking to downgrade from a 2014, let's say September 30th of 2014 is your priority date on EB2 and you're trying to downgrade it now, you have to show, and your perm was approved in 2014 obviously, so you have to show the ability to pay in 2014, 15, 16, 17, 18, 19, 20. So all 6 years you need to show that your employer has had the ability to pay. Now, you also need to understand, due to COVID, a lot of employers did not do financially well, right? There was a loss of revenue. So if that is the case, it might harm your petition. So again, food for thought. I'm not saying don't do it. I'm just telling you guys what the implications are when you downgrade, and so that you can make a educated and informed action. Now, one of the things that we suspect, and more than anyone else, immigration lawyers, we have been very skeptical of the current administration and any action that they do, because they have been so anti-immigration that our conspiracy theories keep running in our head as to, hey, if something is happening, why is it happening? Right? We don't take anything for granted these days. Unfortunately, that's how we've become tuned in the last 4 years. One of the things that concerns us is the current administration has always talked about merit-based immigration. So they want to give visas to people who are more qualified. That being said, if you downgrade from an EB2 to an EB3, you're saying an EB3, which is a lower merit-based, which is lower on the merit-based system, that doesn't make us feel good, right? It makes us think, why would they want to help EB3? Now, what happens if they opened up an EB3 and an overzealous officer says, okay, I'm denying your 140 for an EB3, but hold on for a minute. I will go look at EB2 petition to see if there is something funky and going on, and I revoke that EB2 also. If that happens, you don't have your EB2 and you don't have your EB3. You can come and ask me, Sharda, how often has this happened? It has not happened that much. I know it sounds scary. It has not happened that many times. But is it possible to happen? Yeah, why not? Now, let's take another scenario wherein you decided to interfile. That is, where we have to interfile. What does an interfile mean? You have a 140, you filed your 140s, you have a 140 on EB3 or EB2, you have a 140 on EB3, and you filed a 485 based on your EB3, right? The dates retrogress, which we expected to happen, and your EB2 becomes current, then we'll have to turn the pointer of your 485 to an EB2. Now, when we do the interfile, it is called an interfile. And the pointer turning is done through, actually, it's very funny. We do it through a letter, right? There is no fee that is getting paid, so there is not going to be any receipt that is going to be given. So once you file it, you file it, and then you'll have to basically wait. And what if during this time EB2 retrogrades? You will definitely get an EAD card and an AP, but then you are basically jumping between your AC compartment and your second class compartment, and you're gonna just get a headache given the difference in temperature because you haven't reached your final action date. That is what is going to happen. The other issue that you will face would be with your with CSPA. This is your Child Age Protection Act, wherein when a child turns 21, they will not be a derivative to get a green card through the parents. Now, the only way you can freeze a child's date is when you reached your final action date. If the child was less than 21 by the time the final action date is less, then you freeze the age. Now, if you file an EB3 petition, then you know that final action date is going to take much more time, which means maybe your child will age out. So think about it. So kids who are in the 14 years, 15 years time period, you guys would really want to consider it. That said, people can ask me, Sharda, you gave us so many warnings as to what not to do. So why are everyone doing a downgrade? Because there are so many people who can, the spouses and families who could possibly use the AP and EAD and start working. So if you have that luxury, why not? And we know that it can be the pointer can be turned over, and you can move on to EB2. So yes, it is possible. But you need to kind of think about these scenarios. Think of these scenarios. The other questions that we are hearing quite often in our law firm is, hey, my wife went to India and she's not able to come because she's not able to get a ticket, and my dates are currently current. Can I file her counselor? No, you cannot file her counselor. Remember, to adjust your status, you have to be in the United States. Now, the follow-up question that we get is, hey, she's stuck outside. I don't care about her, right? That means you've just been married too long. And can I just file mine right now and add her later? Yes, you can do that. You can do it as a following to join, but you would be able to do that only when the dates become current again. So, and when the dates become current, what happens is you'll have to think of it as a multi-thread application, right? You have your thread going, you have this your spouse's thread that just spawned off. You'll have to make sure that USCIS realize that there is a dependency between those two threads. So that gets tricky. So if your dates are current, your spouse is outside the country, yeah, it might not be a bad idea to get them inside and file it together. I know I spoke very fast, but I'll be happy to take any questions, sir, uh, questions so that
Yeah, thank you, Andy. Thank you for answering. So you have come up with a good list of the questions and the most common scenarios that people get in this in these with this advancement in the dates for EB2 and EB3, the employment category. So I'd like to ask for Rajendra Katragada and Banu Lanka, if you have guys have any questions. Sharada Garu is happy to take the questions, guys. Let's go one by one. I hope you guys have sorted the duplicates out. Um, One common question I saw before giving it to you guys is basically if there is any, what happens if one or the other is denied, right?
one. So yeah.
Sorry.
So again, sorry. So again, uh, remember, think of it as two tickets. It's a very
Two
simple
tickets.
analogy that we have. Think of it as two tickets. Basically, you don't have a ticket on your AC compartment. You'll still ride on the train on your second class compartment. There is no harm, no foul.
You'd still reach your destination, but without the AC
You'll
compartment.
reach it late.
Yeah. Okay. Uh, yes. Go ahead, Banu. You have any questions for her?
Um, we have a couple of questions that we received from the online form that we sent out. The first one is if EB2 to EB3 downgrade applied with 485 concurrently, then will USCIS work on I-140 application first, and once it's approved, then will they go for the 485, or will
It
they
is
work on?
done. It is done concurrently. So what it means is they will receipt your 485 along with your 140, but they will wait to issue your benefits, that is your EAD and AP, based on your 140s, based on your 140. That's a fair question. And also, to add to that point, please note that there's a biometric involved, and the biometric centers are still not functioning at its 100% capacity. So there may be a delay in getting your AP and EAD in any which case.
Okay. Another question is if a 485 application along with downgrade of EB2 to EB3 is in process and EB2 eligibility comes, can we file for another 485? Or do we need to make changes to the existing?
You cannot file another 485. You need to really point your current 485 towards it. Because the station is the same, so you already climbed on that train. You cannot recreate another train.
That's fine. All right, Rajendra.
So there was another question. Someone asked, we moved to EB3 and final action date for EB2 moved forward. Can we move again from EB3 to EB2 and apply for
Yes.
final action date in EB2?
Yes, you can. Yes, you can. You need to talk to your lawyers who filed the 485 and they'll take care of you.
Okay, this is a question from someone on our live sessions. My priority date is 2nd January 2015 in EB3 category. Just missing one day. Will the current adjustment help me? Anything? Am I eligible to apply to have to wait for the next dates?
They have to wait. There is no way they can apply right now. It's a waiting game still for them.
Well, there was another one on YouTube. Say, I have an approved labor and I-140 through an ex-employer. I do not have a perm or I-140 through my present employer. Is it safe to seek I-485 through my ex-employer?
If your ex-employer is willing to help, willing to go on record saying that the job offer is still open, yes, you can go back to your prior employer.
Okay, thank you.
Yeah. So what would be the process for downgrading?
What is the process is basically you need to file a 140 and a 485 and you submit it to USCIS at the same time. So technically downgrading is filing of another application.
Another application, yeah. It's like buying another ticket. Yeah.
To extend it a little bit, Sadha ma'am. So when you're saying filing 140 and 485 concurrently, but people downgrading, so in labor there are two different scenarios, right? One is the labor is with the same company all the time, and the second one is the labor is like they ported it to a different company. And so what are the scenarios, like who is more
So it
safer and
really
who has
depends
little?
on always the employer who filed with whom the perm and 140 is approved is the king. Right? So if let's take both the scenarios that you mentioned. The first scenario where employer A has 140 and 485 filed, and you're still with them, so it's an easy fix. You're still working with them. They'll help you with your 485J application, going on record that the job offer is there. Easy peasy, lemon squeezy. Now the issue comes in wherein you have 485 and no, I'm sorry, perm and 140 with company A. You went into company B and company B's policy says that I will start doing it only after 1 year. And it's not yet 1 year and you're basically waiting, which is a very common scenario that we are seeing. Unfortunately, the current company cannot do anything because they have to file perm, which takes close to 10 to 11 months, and then file the 140. And then you have to wait till the 140 is approved, right? Or at least it's 140. At the time of 140, you need to file the 140 and 485. The dates are not going to work. So it may not be a bad idea in those cases to go back, talk to your employer A and see if they would be willing to help you.
Yeah. Okay. So I know we talked about the dates moving. I mean, there is a cutoff date, right? I mean, there is a date for them to. Some of the people are in like 2014, 2013, but can they do it? How can they decide from okay, if I am my EB2 is at this date, and now the EB3 that if that falls in the current EB3 dates, how can they make that judgment? How can they make that call?
Make a judgment call. I wish
I
I
know it's
had
an
a
individual.
solution. I wish I had a good solution for you guys, saying that follow this particular flow chart and or a checklist and get to the this thing. But there isn't none. There are so many different factors that you should be considering. So I'll give you an example. I do better with examples, so I apologize. I have a person whose cutoff, whose priority date is 5/22/2011,
Right.
right? Which is about 7 days away from a week away from the EB2 cutoff date. Now, that person was so enthused and they came to us saying that, can I downgrade and file? Let me downgrade and file. And we actually held him off. We said, no, the November dates, they are saying it is going to move by months. There's no point. Hold off. Now, We did that with a couple of people. We did that with a friend of mine who has it in September, saying, "Hey, wait it out. It's no point trying to downgrade and mess up your application." However, we have people who are in November and December of 2014 who came to us saying, "Can you do a downgrade?" Yeah, all the things that I told you guys, big kahani that I told you guys, I spoke to them and we're going to do a downgrade because they're going to wait for much more time on EB2 than what the current people are doing. So you have to consider that. You need to consider if there is, so we have a scenario wherein the child is 18,
Right.
right?
Yeah.
Now, if they go to an EB3, it is going to take them much longer to get to their final action date, and the child is going to age out. So in that case, we said wait. So there is no right answer. You just have to consider your situation. That's why every case becomes so unique, and so everyone has
Correct.
to think about. It is very attractive. I'm not going to say it is not, right? It is very, very attractive to downgrade and file, but please think about whether you should or not.
Any predictions? Anything?
Sir, if
Anything to
only,
mention?
if only I had a
If
magic
only.
ball and say what is going to happen, I would look for the lottery ticket. But no, what we are hearing right now from
Yeah,
Ayla and
that's.
Charlie Oppenheim is months is what they are saying for EB2. So if they are saying months, I'm expecting at least 6 to 7 months on an EB2. And because so many people are going to file on EB3, I don't think EB3 will move forward, EB3 will retrogress. This is my guess right now.
Yeah,
Okay.
also there's one questions like always people are talking like, oh, you are in EB2 and 2012 or 2013. Uh, don't try to downgrade. Is it like there's a different thought process there, right? Some people are saying, oh no, you have to do it because you'll get your EAD, but some are saying no, don't do it because it's EB2 will
It's
move.
very close. Exactly. So if that is the thing, right? When we know EB2 is going to move, just wait it out. You'll be able to file it sooner because you'll get your green card sooner. EAD and AP is a short-term goal. Your long-term goal is to get your green card. So if you wait it out, you will achieve your long-term goal sooner. So the dates are important and the scenarios become important. But
Hey, I have
that
a
said, the
specific.
biggest worry that I have is really the conspiracy theories that run inside a immigration lawyer's head these days. It's unreal. You would not believe how much we don't trust anything that information comes out. We don't take it as a good thing. We always become so skeptical as to why are they doing this? What is the fraud that they are trying to pull here? Right? So that makes us become very, very conservative in nature. I'm usually not this conservative, but with 485s, I am. Because people have
Okay.
waited so long, I don't want to jeopardize it.
I
Yeah,
have a
yeah,
question
Banu,
from my.
Rajendra,
It's a
any other
specific
question?
Yeah.
question.
So,
It's a specific
yeah,
question I
someone
got
has
in
a question
text.
here. Yeah, go ahead, Kishore.
I have a specific question from a friend. They texted me. If EV3 140 is denied, are there chances to revoke prior approved EV2 I-140 and revoke perm labor certification as well? Does it mean I will be out of status? Will What will be the next steps in case of revoke of all I-140 and perm? Can we
They will
retain
Yeah,
present
I had a
date?
same
Can
right.
we
question.
retain priority date in case of EV2 I-140 revoke?
So
You understand the
if they
question, yeah?
revoke, so it's a building, it's a ladder, right? You're building a Lego ladder. What you're saying is they pulled out the underlying Lego piece, so everything falls. So this is the exceptional scenario that I was talking about. If it happens, what will mean is suppose you are in the country for more than 6 years on your H1, your underlying reason to get your H1 extended falls. So you'll have to leave the country at the end of the this thing. You won't be able to get a H1 extension. You'll have to restart the process all over again.
I see. Okay, okay. Yeah, go ahead, guys. Go ahead.
Go ahead, Rajan.
I mean, someone is specifically asking, my date is May 16th, 2015, and I'm in EB2. Is it better to wait for November bulletin or go ahead and downgrade now?
I'm sorry, sir. What was the priority date that you said?
It was May 16th, 2015.
May 16, 2015. They are not current on an EB2 or an EB3. So they don't have anything, they cannot do anything but wait. Because the cutoff for EB3 is January 1st of 2015, and they are May of 2015, right? There's nothing that they can do, they
Yes.
just have to wait.
Okay.
But yes, if they want, they can ask their employers to go file another EB3 140 and sit on it. That's not a problem. No harm done.
Okay.
Here's a question from one of our viewers. If we submit 485 application now, and in the future, if we are eligible for GC with kid sponsorship, can we use that?
Yes. Your attorneys would have to write a letter explaining, and you should be able to leverage it.
Awesome. Thank you.
Family-based petitions are given a preference over employment-based petitions always.
General, yeah. Hey, Banu and Rajendra, did we get
Sure.
did we get the questions from the
Yeah,
forum?
I got one question. It's talking about financial sustainability. Like they're asking to provide asset information to show self-sustainability, and what is the minimum
Oh,
amount
yes.
here?
Yes. Sorry, I forgot to talk about it. My apologies. So there is a form called I-944. An I-944 is supposed to be submitted with your petition. USCIS's rules says that if you file your 485 before October 12th, they will ask for it through an RFE. But if you're filing your petition after October 12th, you absolutely need it, otherwise they will reject your petition. And a 944 is basically they're asking you that information to make sure that you don't become public, you won't be a public charge. So you have enough assets that you won't become public charge. So that is the reason why they're looking for your credit score, how much debt you have, how much money you have. So you need to provide your attorneys with the bank statements, credit card statements. If you're filed for bankruptcy, we need to know now. A funny thing happened a couple days ago. A client of mine asked me, "Hey, are you asking me this information and you'll determine your legal fee based on this?" No, it's not for me. It's USCIS who's asking it. So yes, you need to do this even if you're filing for a child. The 944 takes quite a bit of time, sir. It takes us about 5 hours to prepare one 944.
Wow.
So sooner we get the information, better it is. I'm telling you, it is not fun doing it, but it is something that we have to complete. And
So is there any minimal that they have to show, like at least like some minimal amount that they have to have in asset, or?
No, there is no such thing as a minimum. As if you really want to look at the minimum, you need to make sure that you're not under the poverty lane range. But in my opinion, because most of these are employment-based petition, you are getting paid high enough that you don't fall into that category. But what becomes tricky is if you're sitting on, say, $1 million credit card loan, then we are talking trouble. So you need to look at it.
Another question from one of our viewers is it fine to submit just the affidavits for date of birth certificates? They're trying to get NOCs, but looks like it's taking a while in India to get those. So.
Right. Affidavits would work. Affidavits from your parents, preferably, to then relatives, works. You can also provide, along with it, if you provide secondary evidence such as your 10th mark sheets, any Aadhaar cards, if you have any government-based, it really helps.
Yeah, I guess that's the main thing. A lot of places now I heard, like, if you don't have an Aadhaar card, they don't want to give you a birth certificate. So,
Yeah, and it is so funny. Yesterday, I was talking to a client of mine, and he wanted an NOC to be issued, and they asked for the TC from school. I mean, this guy is 45. How is he going to have TC from school?
Another question from one of our viewers. I have USCIS question. Does USCIS question if GC perm wages are not met or not since the priority date when downgrading from EB2 to EB3?
Okay, this is where it's going to get tricky. It is, they shouldn't question you, the employee, that you're getting paid less than the PWD wage, because as long as the employer is saying that in the future that he will pay them because it's a future job opportunity, you should be fine. But the issue comes here that the employer has to show that he or she has the difference, the company has the difference that they can carry on their financial record. So if suppose the PWD is for 150 and the person is consistently being paid 100, right? Year over year, the company has to show that they have that 50K additional available to pay. If they don't, you won't be able to get your EB3 I-140 approved.
Awesome, thank you. Another question. I'm sorry. I think I have my approved I-140 and my priority date is October 2013 in EB2. But my employer CTS is not supporting to downgrade. Is there any other way to downgrade without my employer help?
You have to pretty much find another employer who's ready to file your perm 140 and then move. It's a very common issue with CTS, Infosys, and the others in that
So
spectrum.
coming to the same question. So obviously, if your I-140 is approved with the one employer, so you move the employer. Now you have no relation with the old one. So can he apply for perm 140? I mean, like labor I-140, 485, all concurrently with the new employer?
No, you can't file
Right.
for a 140 without an approved perm. I wish, but no.
So, but still, he can use that form, right, with the old employer. Yeah.
He will be able to use the priority date. Uh, uh, no, let me understand. The current employer has to have a perm and 140. He can go back to the old employer and use the same perm to downgrade. That is absolutely fine.
Okay. So, but with the new employer, you can't do all three together.
All three in one go. You can't, no. Your biggest pole in the tent is going to be you're getting your perm approved.
And this one seems to be a common question. What are the options for kids at the age of 21 if parents and children continue to file I-485 now and use the EAD advanced payroll and the priority date will not be current by the time they are 21?
So you should consider getting the child, transfer them onto an F1 or whatever, another visa category. You don't have a solution to get them a green card immediately, but what you could do is 5 years after you get your green card, you can see if you become a citizen and you see through your citizenship, can you file a family-based petition for your child? Remembering that unmarried kids have a better preference category than married kids. So something to think about. But if they are, otherwise the child will have to maintain their own immigration string on their own. They won't be able to ride on their families.
Got it. A question from Harsha. I'm the primary applicant on EB2 with PD in November 2009. My wife took a job recently in another state. Do we need to have same mailing address via AR11 form or is it separate address?
Because you'll be filing two separate 485s, you can maintain two different addresses. You can also talk to your attorneys and ask them to make it easier. You would want to talk to your attorneys and make sure that all receipt notices, cards, everything comes to your attorney's office. So that is definitely doable.
Rajendra, do you have anything?
Yeah, I'm checking. There are some. Someone said if we downgrade from EB2 to EB3 now and final action date is not current for few years, Can I go out of country for 1 year and file EB1 with the same employer?
You you can and you definitely can. There are means and ways to do it, but how you'll have to do it, it'll take more time than I have right now to explain, but it is definitely possible. Just to please make sure when you're stepping outside the country to keep your AP alive.
Okay.
Right.
Yeah, I mean, if
All
you
right.
compile all these questions, most of them are, can I downgrade? Can I downgrade kind of questions from EB3 to
I know,
EB2.
I know.
Yeah,
Yeah, that's one common question always is like only the people that are very close on EB2, right? Like to
right.
2012, they are still debating like, do they want to downgrade or just wait for the bulletin to come out? So, what is your, I mean,
So,
like a recommendation? Like, is it good to wait?
so I would wait if you're very close. See, typically the November bulletin should come out on worst case 17th of October. You can, based on that, you can decide to file after that. If the dates moved, you file in November with your 485, else you can downgrade and file.
So
Easier
and
solution.
can we say the close can be a 1 year term or like 2013?
I,
The prediction I
I,
asked.
I really don't know, sir.
Some people think it's I'm just a month away. Some might think I'm a year away, but still close. So they're looking for a suggestion on that.
Yeah, so at this point, all I can tell you is the information we are getting is they are saying months to us. They are not saying years. So that is why I said I'm looking, if I understand how it will work, and I could be wrong, it would move by 6 to 7 months is my guess. But we can wait till the 17th, see how the November visa bulletin moves to make a determination.
Got it.
Yeah,
Yeah,
those
one
are
other
the
thing.
questions we try to get them earlier.
Yeah.
If I were in that situation, I would worry about those scenarios as well. So, hey, Raj and
Yeah,
Banu,
there is another important question.
can we ask the questions one by one and see if it is an yes or no question, then we can quickly pass through the questions so everyone's questions get answered. Can we do that, please?
Sure. So, question from Deepthi here. Can we file 485 with employer A, with whom I have an approved I-140? I work with employer B. Is it better to shift to employer? When is it better to shift to employer A, after EAD approval or after GC approval? Immediately after
So
H1?
you absolutely have to shift after the green card approves. If you want to shift now, no harm, no foul.
Got it.
But again, it depends on the agreement that you have with your employer.
All right.
Okay, someone had a question on the bad credit score and high debt to income ratio. Is that an issue with 485?
That would be an issue with 485. We need to analyze it at a per case level to see how bad the situation is. But yeah, it may become an issue.
Okay, so other one. I have I-140.
Even if it is related to green card or not, you must always fix your credit score.
Yeah.
In general. Go ahead.
So next question I have was, I have I-140 approved 2015 from employer X. My current employer did not port last I-140. So I have another 140 in 2017. If I file an EB3 with current employer, can I use the 2015 I-140?
Absolutely.
Okay.
You can have multiple 140s with multiple employers, and you can use the oldest I-140. That's absolutely fine.
But does it mean like they have to go back to the older employee and talk to them, or?
You would want to talk to the older employer and see if they'll be willing to help you out because they have to file the 485J. Now, some employers may not be willing. Some employers, I can tell you that a lot of employers
So
are
I guess,
using this as a
yeah.
reason to hire people back.
Yeah, I think the question was like, I'm with the new employer, and obviously, can I get that a 140 that is approved in the other employer and use that here to
Correct.
file the, yeah, so.
You can use the same 140 from employer A and move it to the employer B, but the employer B has to have done the perm and ask them to use the same priority date.
Okay. All right. So the new employee has to do that perm before. Yeah.
Here's a tricky question from Chetan. If another lockdown kicks in and travel bans are in place and consulate closed, how many family-based visas overflow?
Your guess is mine. Your guess is mine, but I don't want that lockdown. I'm done. Please don't do that. I booked my tickets to India already. Don't do that to me.
So I have I think he's from India. He's waiting on his H1B approval. The new H1B.
Kishore, sir, you're too soft spoken for me.
Okay. Yeah. Can you hear me now?
Yes.
Yeah. So these guys are from. There are some from India waiting on their H1B approvals. Is there any? They are stopped due to this COVID situation, right? Or are they running now, or do we have any information or insight into that?
The consulates are slowly opening. I know that in March, at least, there are a lot of seats, a lot of visa openings that are coming up in March. This is as of yesterday that I know of in Hyderabad. So it is moving. Now you would want to see if you come under the presidential, the exception to the presidential proclamation. So they made a couple of exceptions, right? So the last time we spoke, we had a big proclamation said no one could enter. Then they kept chopping it down, saying who can come in. So you'll want to see if you got chopped, you're now allowed in. So you would want to consider Dropbox also. Most of the consulates are doing Dropbox. Mainly if it is an extension petition that was filed and that you're with the same employer, you can definitely come back in. Now, if you have a situation wherein you're working with any COVID-related thing with your company, for example, you're working with a pharmaceutical company and the company is doing COVID, this thing, you can get an exception based on that.
Okay. Thank you.
So someone had asked if my employer is not supporting the downgrade, will there be an option for me going without employer's help?
You remember, it is an employment-based green card, so you need the employer to help you.
Right. Okay.
Scrolling through the questions, I see most of them are common, but most of them are asking for suggestions.
Yeah, I think there is a misconception that UCS is allowing premium processing. I don't think premium processing they're allowing, right?
Okay,
For this downgrade.
so this is the deal. Can you premium process a 140? Yes, but when you downgrade, so when you're doing, let me extend it a little better. I apologize. So you can do premium processing in general. But to do premium processing, you need to submit the original perm, copy of the perm. The blue sheet that we used to get. Now, if you already have an approved 140, that means you've given your original perm to USCIS already. Now, if you're asking them, so you don't have the original perm, so you cannot do premium. What will happen if you try doing premium? Right, then what USCIS adjudicating officer has to go to DOL and ask them to give out a copy within the 2-week period so that they can work on it. Now DOL is not going to be cooperative. So they may get frustrated and either give you a very nasty RFE, or they may say, you know what, I'm denying your petition, in which case the 485 cannot be filed either, and it comes back to you. One of the things that you can do is if it is the same service center, so the service center that has your EB2, your EB3 is going to the same service center. Once you get your receipt notice, after a couple of weeks, you can file a premium at that time. Because if it's the same service center, they have to go in their service center, pull out the file and take out the copy of the perm. That is the thought process.
Another question from Ganesh here. Will child be allowed to file an F1 when he's in EAD with 485 pending? One of my attorneys says it's difficult. That's what.
It is very difficult. It is very, very difficult. So one of the things that we are doing in our office right now for a few people, is we are filing their F1 first, change of status to F1 first, and then we are going to file, once we get the receipt, we'll be filing their EADs. Because, and the reason is this, F1 is a single intent visa. That is, you're going to show that you're going to come back to your country. By filing for your 485, you've already shown your immigrant intent, and which means the basis of F1 is gone. So that's why it is very difficult. So file your F1 change of status and then file your immigrant petition.
I think this is a repeated question, but I'm going to ask anyways. Say today you started working on EB3 EAD, already have an EB2 I-140, EB2 dates become current. Can I start into filing 485 on EB2, or do I have to be on H1 to do that?
No, you can interfile. You can go back to and EB2. Now that said, the advice that we always give is try to stay on your H1 as long as possible so that it is easier. Because once you move to an immigrant-based petition, you cannot go back to your non-immigrant-based petition, right? So it's a good fallback option to keep using your H1 and then keep this in the back pocket.
Does a downgrade from EB2 to EB3 with a previous employer possible?
Yeah. As long as your previous employer has the ability to pay and is willing to support you. Yeah, absolutely.
And,
I have a question related to the physician NIW EB2 to EB3 conversion. Is that
and NIWs cannot, NIW, what an NIW means is a national interest waiver. That is, they're not going to do a recruitment. They're saying that, boss, forget US worker. This guy is so great that give him a 140. That is your NIW. There is no perm. So how do you downgrade from an EB2 to an EB3? You can't.
So the answer is no. Okay.
No. It's a nicer way of saying no, sir.
Yeah.
Yeah, I guess we right almost 1.5 hours. Yeah, we lost a few minutes in the beginning, but yeah, let's go quickly with any few more questions, and
Yes.
I know Shazam is giving us a lot of time, but
yeah, sorry, one common
ahead.
question that we received is if both spouses are on EB2 with different priority dates, they're asking if one should stay on EB2 while only the other one is downgrading.
That makes absolute sense. That makes absolute sense.
Okay, so yeah, that's the question they had. Is it suggestible? So thank you.
I have a question
there is
from
another
another
question.
friend. Go ahead.
Yeah, go on. Go on.
Yeah, I have a EB2 I-140 approved, and I plan to downgrade to EB3 and apply I-485 with the same employer if it's approved. Until what time can I keep both EB2 and EB3 active? Would there be any administrative challenges to use final action dates for EB2 if it becomes current?
First, it's your employer who can decide whether you can keep both. You don't get a choice. And if the employer is willing, yeah, you can keep maintaining it until such time that you can, the final action dates become current for EB2 and you just turn this pointer of EB3 towards an EB2 and get your card sooner.
Correct, yeah. Makes sense. Okay.
yeah, Rajendra,
Go ahead, Raj.
No, someone said I have a H1 amended for another location, but I never moved there. Am I eligible to file I-140 downgrade from the current location?
As long as your employer's principal business location is the same, your file irrespective of whether you moved or not. So let me explain. The employer A is in California. You can downgrade from EB2 to an EB3. That's not a problem. Suppose employer A moves its headquarters from California to Texas, then they should have amended the 140 because they moved the location. They would have to test the labor market in Texas. So irrespective of whether you moved or not. Clear as mud.
Right.
Yeah.
You asked clear as mud, and we all said yes. So, so yes.
Yeah, interestingly, with this financial question that we had, people are like, is my mortgage loan gonna be a problem for me now?
No, mortgage loan is not a problem as long as you're continuously paying it. So I will say what all are going to be issues. If I have a couple of minutes, I can walk you down what all are going to be
Sure.
issues.
Yeah.
Issues would be you claimed rent exceptions. It is very common in California, people saying that they don't have enough money and they claim reduced subsidized rent. That was going to be an issue. You use Medicare or Medicare, that would be an issue. Claiming food stamps, that was going to be an issue. You filed bankruptcy in the past, man, you're in trouble. Um, so those are the things that they are looking for. Just because you have a car loan right now, a mortgage loan right now, or you have a loan with Fannie Mae. I can't remember the name of the loan with Fannie Mae, wherein you can put a pause to your mortgage. That is not going to be an issue.
Yeah, that's good. Yeah. Okay, guys, any other questions? Or still, if we are getting the same repeated questions, I guess then
Yeah.
we can move.
Those are, yes.
Yeah. Any final thoughts before we wrap it up, Sharadaji?
My only thing is please talk to an attorney and file your petitions. Don't try to do this by yourself. It's absolutely not worth it. That is number one. Two, please really think if you should be downgrading and file. Um, I know it's exciting, but not everything that is glitters is gold, so you should be careful.
Right.
That's a good one.
Yeah, President, you have
Okay.
any
And someone,
final thought? Any? Okay, go ahead, Raj. Go ahead. Go ahead.
no. The users are saying, thanks, Sharda Kodem Garu and Nats for doing this. Sharda Garu, you have been very clear in what you explained to us. Thank you so much.
Thank you.
Oh, that's good. That's great. That's why we're doing this. Thank you, Sharadaji. Yes. Go ahead, President. You have any final thoughts? Anything you want to say to the viewers, to the
Obviously, thank you everyone joining first of all, and all the questions. And Shada ma'am, thank you patiently answering it. Initially, we had some technical issue, and I really apologize for that. But thank you everyone to be being so patient and staying there and making this webinar success. I really appreciate it. Thank you everyone. Uh, one last question, someone, because I was talking about this financial thing. They're like, "Oh, wow, how much would be the debt to credit ratio should be at least?"
So as long as you're able to show that you have more money than the poverty rate, right? And that's easy. Just go and Google the poverty line. You would know what the money is. I'm pretty sure most of us are fine. As long as you have more than that, you're good.
Okay. Oh, perfect. Yeah. Anyways, thank you, ma'am. Really appreciate it for giving us time.
yes.
No problem. Thank
It's
you so
really
much for
always,
having me.
you've been
So
always,
It's
yeah,
fun.
it's been in a third webinar with you, and you've been always so nice. You always accepted our invitation. Thank you very much, really.
Thank you so much for
yeah,
having me.
before I conclude this webinar, I would like to extend a sincere thanks to Sharada Garu for accepting it and patiently answering all the questions to viewers. It is always pleasure having you on this webinars and getting more information, clear and precise information on these questions. Though there are all ambiguity in all, there are some of them beyond in our control, but you did a good job on explaining all those and then trying to advise the viewers not to take risks and all the other things. So, being said that, I would like to thank President Garu also for President Garu for conducting a webinar in time. In the need of this hour. This is a need of this hour because there is a lot of there is a lot of excitement with this bulletin that came up. So thank you, President Garu, and like to thank Raj Kantragadda, our chapter coordinator, for compiling the questions, and Banu Lanka, our zonal vice president, for compiling the questions and staying with us. Even though he had muscle spasms, he still stayed with us and then asked all these questions. So thank you, Banu. And I'd like to thank NRI Streams, Srinivas Vuyurgaru, for hosting this, for supporting us with this NRI Streams webinar and platform, and giving us a chance to connect with all the viewers, and get all these questions answered for all our for all the viewers, and who had questions. We had a nice platform. Like to thank Sudhir Kumar Nikilneni for our web promotions, and Srinivas Kakaman for promoting in the social media, and the entire Dallas team stood behind us, who supported it throughout the event. So thank you guys, and if you still have any questions, you can use the forms page and ask more questions. And if you need any more questions, you can contact Sharda Garu. So she gave her contact number earlier as well in the presentation, and you also can post it in the forums and on the live, so we can get these questions answered. Like she advised, do not try this at home. This has to be this has to be under the expert
Guidance of the professionals.
under the expert supervision. Yeah, please do not try anything risky at home. And thank you for joining us today.
Yeah, and once again, finally, I would like to say NATS is always there. 24/7 helpline is there. So our helpline number is 1-888-4 Telugu, and helpline at natsworld.org for email. Please note that down, and hopefully you will stay safe, and keep rocking. Thank you, everyone.
Thanks. Bye.